Let me introduce our wonderful guest speaker. She's back by popular demand. She came on as panel as a guest speaker in January. So Diana is very experienced as a state attorney. Her office is in Los Altos. She attended Santa Clara University School of Law, and she's the founder of Gendotti Law Associates. And I always leaned on her wisdom whenever I had the sticky estate planning questions. So without further ado, thank you, Diana, for joining us today. And let me hand over the controls to Ashley here. And welcome today.
Arvind, thank you very, very much. And thank you for everyone who is attending. Arvind is already working his magic today. I already have a full page of notes of questions for Arvind later. But I wanted to just touch upon how Arvind has talked about you are working with him as your financial advisor, and it's a natural progression from financial advising and financial planning to look at your estate and your assets and to ensure how do they pass on in the event of your incapacity or your passing. So when I mentioned too that Arvind is working his magic, if you notice, Ashley Gendotti is also on this seminar. I'm very lucky. Ashley is my daughter-in-law. My name is showing up as Ashley as well, I believe. So Arvind has magically taken 31 years off of my life and made me look a lot better and a lot younger. So thank you, Arvind, and thank you, Ashley.
Thank you.
So we should just end the presentation right now. It doesn't get any better than that.
No, the best is yet to come.
Okay. So in this presentation, you'll see that we are quite enthusiastic. For some reason, I absolutely love estate planning and trust administration. And I think part of that touches upon one of the slides that Arvind had about the different tax buckets. And when Arvind was showing the different tax buckets, I was thinking this is very much like estate planning, that we are looking at what are the buckets of how your assets are set up and how do you ensure that you have a person or people in place to help you if you become incapacitated. And if the unlikely event happens that will occur, that you pass away, how have you ensured that these assets will go to who you wish to receive them or a nonprofit that you wish to receive? So thank you, Arvind, and also thank you, Ashley, and thank you everyone who is in attendance. So the first slide, I believe, is, oh, thank you. So Arvind said, he said lots of good things already, but one of the things Arvind said was what worked and what didn't. So with estate planning, probably one of the best things is to be prepared and to be working with Arvind and your advisors to make sure your assets, as I've mentioned, are set up the way you wish them to pass. This first slide, I will not go into details because I don't think you want to hear me talk about your third cousins thrice removed. But this table of consanguinity, this is in the California probate code or the law, and this is who the government deems should be your beneficiaries of assets if you do not have a beneficiary on the asset, or if you do not jointly own the asset with someone, or if you do not have a revocable trust. So when people say, I don't have an estate plan and the state will take my assets, I just point to this to say, well, actually the state of California will not take your assets, but the state will show who would inherit from you. So that is just a reminder that you have an estate plan, whether you know you have one or not. Most people, of course, want more control than that. And so that is where we look at doing estate planning documents, whether powers of attorney or will and trust. Okay, so the next document or the next slide that we have is, you probably have heard the word probate. Probate is the court process in California where when someone has died, probably the best way to describe it is with assets that exceed $166,250. And here's the and there's no beneficiary designated on that asset, either by beneficiary designation, such as a retirement account, or that it's held in a revocable trust. In general, we're going through the court process known as probate, and no one likes probate. Although I haven't checked with the probate judge. Maybe the probate judge likes it, but attorneys and clients prefer not to go through probate. And one of the reasons is that it is a public process. It takes a long time. And the third part of it is that the attorney's fees and the executor fees are based on the gross value of the assets. So this first slide is just showing how are fees calculated for the attorney and for the executor. And without even going into much detail on the slide, we will just say a lot. So the next slide shows some examples of how the fees calculate out. And so being in the Bay Area and in Silicon Valley, if I look at the right-hand side and taking as an example, if there's a home that is worth $3 million, so that is on the right-hand side, almost 2/3 of the way down. If the gross value of the home is worth $3 million, you can see on the right-hand side, there's a number that says 43,000. That means the attorney's fees to take that house through probate would be 43,000. It means the executor would also be entitled to receive 43,000. So we're up to $86,000 in fees just to get a house through this court probate process. And the probate process typically takes, on average, about 2 years, although we try to do it faster, but have found that with COVID, everything takes much longer. So these couple of slides are when Arvind said what worked and what didn't, these slides are what didn't work so well. The next slide is showing how do you work with your estate planning attorney and advisors to take control over your estate plan and prepare documents that will reflect who should step in and make decisions for you if you're not able to do so. And the first slide that you can see here is just talking about your healthcare documents. And we all know with COVID how important it is to have these in place so that if the unthinkable happens, your intentions are known. And we've got 6 bullets here because that's just representing 6 different documents. And I'll just go through them briefly. The first 3, the HIPAA, the authorization for release of protected health information, just is indicating who can talk to the doctors and access medical records. The next, the durable power of attorney for personal care decisions, is really important if someone becomes incapacitated, because this document is saying who can step in upon your incapacity and make your daily personal care decisions, such as where you live and who will care for you, in addition to food, clothing, and entertainment. So that's an important one. And the third one, the Advanced Healthcare Directive, is also important. This is saying, who are you designating to make medical and end-of-life decisions if you're not able to communicate your own intentions? The next 3 on this slide are showing the Do Not Resuscitate form, DNR, the POST, the physician order regarding life-sustaining treatment, and the Natural Death Act. These are all more detailed documents that you complete with your physician to designate your end-of-life intentions, such as the do not resuscitate or do not resuscitate and provide comfort care. And then the Natural Death Act is in California if someone is terminal and wishes to end their own life. Okay, on that light note, we'll go to the next slide. So as I mentioned, those were the overview of the estate planning documents about healthcare and healthcare matters. Then what we look at is what are the financial estate planning documents that one typically needs. And again, thinking of Arvind's buckets that he showed us, the tax buckets, when we do estate planning, we typically like to look at your assets in buckets of assets that have beneficiaries. So that's the first bullet that we have. Beneficiaries are designated on the assets. So for example, if you open up a retirement account with Arvind, part of that process is going to be, in addition to how much money is going to be in the retirement account and how will those funds be invested, part of the paperwork that Arvind will have you complete is who is the beneficiary of that account. And when we talk about the beneficiary, the unspoken words are when you pass away. Clearly, you're the beneficiary of that IRA while you're alive, but this is trying to designate who is the beneficiary to inherit those assets or receive those assets when you pass away. if you became in general, if you became incapacitated and funds needed to be withdrawn from that IRA while you are incapacitated, you're still alive but incapacitated, Arvin would typically want to see a financial power of attorney. This financial power of attorney would show Arvin who is designated to step in and handle those assets that are in your individual name while you are incapacitated. If you pass away, Arvin already has the paperwork to show who your beneficiary should be. But again, this is to give access to the account while you're incapacitated to be able to work with Arvin on the investments and the withdrawals. Okay, now the next document that we have on the slide, we're talking about a will. And the will is, I've heard it described, the will is, it's more formal than this, but it's like a letter that's written to the judge to say who should take over your financial matters when you pass away and who should inherit your assets, who are your beneficiaries. In many states, a will is a sufficient estate planning document to accomplish those activities. Who takes over and handles your assets when you pass away and who should inherit. The wrinkle in California is, back to that slide, we don't have to go back to that slide, but the slide that we referenced for probate. In California, if those assets that are in your name alone and do not have a beneficiary exceed $166,250, even with a will, you are going to be pushed into that probate process. And again, back to the example, if you own a home in the Bay Area, I don't think it's going to be worth less than $166,250. So this is the reason why in California, so many people have revocable living trusts, because by having a revocable living trust and transferring title to the asset into that revocable living trust is the mechanism by which we do not have to go through probate to have someone take over the asset when you're incapacitated or pass away and pass it on to your beneficiaries. Oh gosh, I know this is getting complicated, but it's just showing that all of these estate planning documents are key to having control over your assets and having the people designated who can step in to handle them if you become incapacitated and who should inherit them when you pass away. Okay, so on the next slide, what we have is the least, well, I was going to say the least favorite topic. Probably death is the least favorite topic, but right up there is taxes. And I know there's a lot being discussed these days about taxes. And so this slide is just addressing kind of what do we know right now. We realize there are changes afoot, but this at least gives you an overview of what is current. So currently, each individual has an estate tax exclusion of 11.7 million. That 11.7 million is how much can you pass on to your beneficiaries, excluding spouses, without estate taxes. When I say excluding spouses is because under the current law, any assets that pass from spouse to spouse are not subject to estate tax. So when we're looking at this 11.7 million, we're looking at how much do you pass on after you pass away, not to a spouse or when the second spouse passes away. The good news is currently there's no California inheritance tax. And the other good news, if there can be good news about death and dying, is there's this tax provision called portability. This is talking about when we have a married couple and the first spouse passes away, we are able to take the decedent's lifetime exclusion. Let's say they pass away in 2021, that exclusion is 11.7 million. We're able, by filing an estate tax return and checking all the appropriate boxes, actually the CPA is doing more than just checking boxes, of course, but it is allowing us to transfer that unused 11 million exclusion to the surviving spouse so that when the survivor passes away, they will have whatever their exclusion is that year, plus this unused 11.7 million. Dovetailing into that, when we talk about someone passing away, I have a note here about the income tax, capital gains tax. And I know this is getting a lot of chatter these days, would probably be a good word for it. Currently, when someone passes away, their assets step up in basis, income tax basis, to the current fair market value. So I don't know why I keep thinking about a home that's worth $3 million. But if we have someone who bought a home a while ago, and that would be, and let's say they paid $100,000, which is hard to imagine. And when they pass away, or the first spouse passes away, we would reset the basis of that property from $100,000 up to $3 million. We would get a real estate appraisal to show us that the house is worth $3 million. If the survivor or the trustee decides to sell the home, there would only be capital gains if they sold it for more than $3 million. So we're looking at, when someone passes away, this step up in basis, which wipes out the appreciation that would otherwise be subject to capital gains and resets the basis. What this is bringing up is, when someone passes away, we need to be working with the financial advisor, Arvind. We work with the CPA, and as a team, kind of divide and conquer all the activities that need to occur, because we want to make sure that the clients get these documents in hand, so that as they continue with the rest of their life, they have the appraisal for the home to show the step up in basis. Arvind will have prepared with LPL what is the step up in basis. I'm making this up. If you happen to buy Facebook at 10 and now it's worth 1,000, Arvind will have prepared the paperwork and adjusted in the account to show that the basis has stepped up, so that if you then sell Facebook at $1,100, you're only paying capital gains tax on 100. I'm probably getting into too many details here, so let me keep going. The last bullet on this slide is real property taxes. And this has changed significantly in the last few months with the last election, and the passage of Prop 19. I won't go into what the law was before, or really what the law is now, but the real properties, we see that step up in basis. We also see an increase in real property taxes, not spouse to spouse. If the first spouse dies, the property taxes do not go up for the surviving spouse. But after the surviving spouse passes away, or if a single person passes away, we see that the property taxes will go up to fair market value with certain limited exclusions. Okay, I've probably said more about taxes than you want to hear. So I will go to the next slide, which is a new slide. So if you were here last time, we knew that we should add something more to this presentation. And I think one of the things that we find in doing estate planning is that we are happy to work with people, especially nice, wonderful people, but we're happy to work with people to prepare their estate planning documents and to update estate planning documents if they already have documents in existence. But part of the strength of those documents is making sure that they are appropriately tied to the assets, and that the assets are integrated into the documents and vice versa. And so what we always want to make sure of, especially when we've prepared a revocable living trust, is that we work with the clients and we work with Arvind to say, how are these assets held? How should they be titled? So we've just put this slide together to show that there are various title options. Is it going to be in your individual name? Is it people that are going to own property together that maybe are related but are not spouses? Are they going to hold it as tenants in common? Joint tenants, community property with right of survivorship, and then the last is the trust. We want to make sure what best fits the asset. And on the right-hand side, we're trying to show the variety of assets: real property, timeshares, stocks, non-retirement brokerage accounts, your business interests, cash accounts, vehicles, and safe deposit boxes, to make sure, are these assets properly titled based on the various options that are available to us, to make sure that if you became incapacitated or passed away, that again, we're not going through that dreaded probate process. We realized also, as the next slide will show, there are some assets, like I've mentioned, when you open up a retirement account with Arvind, that you can designate beneficiaries on these accounts. So we've listed those out. Again, it's not all inclusive, but it just kind of just giving you some examples. Retirement accounts, pension plans, life insurance, annuities, stock options, RSUs, the long-term care insurance, and health savings accounts, just to make sure when possible that we have beneficiaries. And so on the left-hand side, we've just kind of shown what are the designations. Is it a spouse? Is it a child or children? Do we use a trust name? Do we use an individual name? Again, making sure as you prepare your estate planning documents or review your estate planning documents, that you are reviewing your assets and making sure that they're connected to the documents. And I think that is probably the biggest, if I can use the word, maintenance issue that we see, is to, when people do estate planning documents, as they go through life and buy another piece of property, open up a new account, a new bank account, or they work with Arvind and they want to open up a new brokerage account. How do we continue to maintain the integrity of the documents by continuing to circle back? How do they need to be integrated into the estate planning documents? Okay. We also realized that we should probably share with you, as the next slide shows, what are some of the things that we are seeing that are becoming more and more of a concern. And so these are starting to be kind of, what is it? Our war stories. We're finding that passwords are playing just a larger and larger role in estate planning. I don't mean that we need passwords for the estate planning, but prior to passwords and so much being embedded in our computers, statements coming online, if someone became ill or passed away, we would, if the trustee or successor trustee did not know much about the assets, we would say, watch the mailbox and see what statements come in. Well, that doesn't work so well these days because so many people have their accounts online, and not everybody has a wonderful advisor like Arvind that knows all their assets. So we are trying to remind people to have their system of how they keep their passwords, whether it's their own system or using 1Password or some of these other companies, that if you became incapacitated or passed away, there's a way to access your passwords, because we know that's the way then to access the financial information and the information about your assets. The next bullet may just sound so silly: identification. Identification has become one of the biggest issues we've seen probably since 9/11, and a continuing trend of needing to have identification that matches how your name is presented in legal documents. One of the things we found through COVID was people needing to sign documents and did not have identification that matched their name on documents, or they had not maintained current identification. And we're not particular. It can be a driver's license, it can be a senior, or it can be a California ID card, it can be a passport, but we're just seeing or encouraging people to pay more attention to the identification so that it does not lapse and they don't have any current identification. Again, it may sound silly, but it has become a big issue in certain situations. The next point I have here is that we are seeing a trend on long-term care policies, which is wonderful. The trend is that the long-term care provider is asking, if you are making payments on this policy and you miss a payment, who should they contact? And so we have a current situation where a husband and wife put each other as the contact person if they did not make a payment, which made perfect sense until COVID came along, and they were starting to fail a bit, and they did not make a payment. The company sent letters to each other, but at that time, their children were starting to take over the payments and monitoring their expenses. And long story short, the again, because the contact person was each other, no one outside of each other had realized that the payment had not been made and that the policy lapsed. So the point on this is, if you're going to put a contact person, it might be a good idea to put someone other or in addition to your spouse in case something happens. Let's see. Another issue that we're starting to see more and more of is that when people are inheriting property, we just want to mention that if they are a married couple and you inherit property, it comes to you as your separate property. And if you receive this separate property and it is going to be an account with Arvind, you can hold that property in your name and you typically can designate beneficiaries. If you want a more sophisticated beneficiary designation plan than just naming names on the account, you may want different percentages. You may want individuals and nonprofits. Again, it may be more than what should really be put just on a beneficiary designation. We're seeing more and more people creating separate property trusts to hold those assets and to spell out the beneficiary designations. They can be added into the joint trust as separate property, but there's pros and cons. But to whether it's added to the joint trust or kept separately, just raising it so that you know it's an issue if you received an inheritance or significant gift and want to look at how to handle it. The last bullet on this of just kind of frequent topics that come up is just kind of an awareness that if someone was going to take over for you, in this case, I'm assuming that we have a revocable living trust, and for some reason you can no longer act as trustee, we often get asked questions, how does the next person take over? And so the next person takes over by, I'm going to pretend that I have a revocable living trust, and I'm going to pretend that I named Ashley to be my successor trustee. So Ashley can take over my revocable living trust. If I resign, I will resign as trustee and Ashley will sign paperwork to accept as trustee. And then Ashley can have access to all the assets that I have in my trust. If that is not the situation, and God forbid, I've become incapacitated, the trust typically provides that Ashley would need to obtain 2 letters from doctors saying that I'm incapacitated. Again, I'm incapacitated, so I can't resign. Ashley would need those letters to then be able to show that she should be trustee and access the accounts in the trust. And then the last way that Ashley would show that she would become the trustee is if I've passed away and Ashley has my death certificate. I mention this only because people aren't always aware of how do they become the trustee after they've been named the trustee. Okay, all right. Last but not least, we have one more slide. And then I'm sure we can get to questions if there are any. The last slide is, again, it's an overview to recognize that when you have all these wonderful estate planning documents and someone passes away, we're just showing that there is for lack of a better word, there's a flow. There's a progression to this of what are the initial activities? What do you need to do typically in the first 30, 40, 60 days, 9 months, year, 15 months. And this is what we would guide you through if someone passes away. Typically, it's like I mentioned on the last slide, to be able to start helping the survivors is that we would need a death certificate, and then all the formal legal activities can begin. Oh, that was not a very lighthearted way to end, but I see Arvind, who will help me make this a little more lighthearted than everyone being incapacitated, dying, having to pay taxes. So thank you. I know this was a very, very broad brush, but it's just hopefully resonating some part of it with you to talk to Arvind, to talk to your estate planning attorney, and just to make sure things are kept current. Thank you.